Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Those of you joining us live today have the opportunity, as always, to ask questions and interact with our speaker. If you have a question, type it into the comment section below, and we will be sure to address it. Episodes are released each week following the live broadcast, so be sure to hit that subscribe button and click the alerts icon to make sure you don't miss an episode. Today, we have Toby Cole with us out of Houston, Texas, to talk about the Openings College. Toby practices personal injury law in Houston in addition to being KTI faculty. And Toby, are you the Dean of Openings?
I was for several years. I am not anymore. I have passed that on.
All right. As always, we'll put Toby's contact information in the description below so that you can reach out to him if you have questions about the Opening College or anything else. Toby, you were the first person to teach me openings. Talk to us about the Openings College, if there's anything different that's happened in the past few years, and what we can expect when we attend.
Yeah, absolutely. So I think, what we talk a lot about in the Edge is the evolution of the Edge and how things change. And opening has done that, and it's done it in a couple different ways. We have the Undergraduate Openings College, and there's a Graduate Opening College. But I remember I took, I'm one of these guys that when I first started doing, the Edge with Don Keenan, there wasn't colleges. It was the books and it was seminars. And so we traveled around the country and we went to these different seminars, and then the colleges evolved. And so there wasn't, 10 or 12 undergraduate colleges and a bunch of graduate colleges. It was the Rules College came out, and then a few months later, the Openings College came out. So I was one of the original folks to take openings, to learn openings. And it was interesting. So it has changed. It has modified through that time. But really, kind of the biggest thing that I learned, especially initially, when I first started taking these courses, is I had a case that was not even filed yet. And so I started taking the Rules College, and I didn't have all the facts, so I had to make it up. And I started taking the Openings College, and I didn't have all the facts, I made it up. And it was liberating. And I tell everybody when they ask me, what classes should I take, how I should take it, what order should I take them in, I tell them, don't take openings when you need it a month from then or 2 months from then. Take openings when you don't even know the facts yet, and when you haven't filed the case yet. And then the Openings College will give you your roadmap for discovery. It'll give you your roadmap for rules. It will give you a roadmap for what depositions to take. And so that really is one of the things that I see with openings, and I try to impart upon, the faculty that I've trained and the students that have taken it with me, is openings is not just what you do at the very end of your case and the weekend before trial. Write your opening when you get your case. And so that really is one of the things I took from the very beginning, and that I think is important now.
Okay. How do you write an opening statement if you don't have the facts? And you talked about making them up, but I mean, how does that help me get through discovery?
Yeah, well, we all know when we have a case, I could give you a 30-second fact scenario, and you'll fill in what you think the case is about. Okay, car wreck, person went through a stoplight. Okay, well, the person was looking at their phone, and this is what happened. This is what happened next. This is what happened next. You write the opening with that in mind, thinking, what do I think this case is about? If it's a product case, this is how the product was bad. This is when they know about it. And then you go, okay, you know what? I need to find out if that's true. So let me subpoena the phone records. Let me find out how long they were at work. Let me look at their medical records for drug testing. So then it tells you, well, okay, what are any of the things that I think this case is about really true? Because now I know I have it with discovery, and I can check mark off the things that aren't on it, or I check mark the things that are, and it gives me a roadmap for what I'm looking for.
Okay. And then is that opening that you create in the beginning the one that you stick with and ride all the way through, or does it change?
Usually not. It usually evolves the entire time because, your opening has so many, it has so many different components to it, so many different sections to it. So what the defendant's excuses are, what you think they're going to be initially, well, then you get discovery from them or they take your client's deposition and you realize, this is what their defense is. Okay, well, let me put that in the section here. And now I need to send discovery to make sure that, okay, my client wasn't drinking. My client did use the product right. My client did have the right training. My client did go get a second opinion, whatever those things are. And so you use that as a kind of a moving document that you're filling the story out. And it gives you the roadmap of exactly what you need to look for to fill out that opening.
Now, opening is kind of an interesting part of trial because it's kind of boring, right? It's just a few moments, there's just some facts, and everybody gets really excited kind of about closing and whatnot. What's the significance of opening in the edge, I guess, philosophy?
Well, and you're right. And one of the reasons, why opening is so boring is because we don't know where we're going. We don't know what we're doing. We just say, you know what? I know the facts of the case. I'm a trial lawyer. Let me just get up there and just, throw it from the hip and then we start telling these long, boring stories and we start, it starts, just meandering and people are going, what are you talking about? And so that is, that's the great thing with the EDGE system is that, I'm okay, thank you. The great thing with the EDGE system is you're given sections, you're given a roadmap of where to go to, you're given a way to keep it simple and not throw, I don't know if you guys have had Greg Luther on here, but yeah. So, Greg's saying that we quote a lot is, don't F up your case. Mm-hmm. Don't fact up your case. And it's so hard for us not to do that because we spend weeks and months and years digging for these facts. I file motions to compel. I hire these experts. I've spent, $5, $10, $100,000 to get these facts. And I want to tell the whole world about it. And so it does get boring because it's not a story. It's just a jumble of facts that we just think we want the jury to know. And it doesn't really give us a coherent, concise story that gives all the elements that a jury needs to know when they need to know it. And so, the other thing that we talk a lot about, that I talk a lot about is, look, you have an entire trial. The opening, you do not need to give every piece of every part of your evidence and your facts in your opening statement. You have your entire trial. You have days, if not weeks, sometimes months to give information. And so using the EDGE system, you're able to figure out what needs to be given to the jury when they need to get it. And that way you keep it interesting, you keep it where it needs to be. And that just makes it a lot simpler.
Papa Don talks a lot about meeting the jury where they are. And part of that is what jurors expect from us as lawyers and figuring what that is. And 9 times out of 10, it's not a 45-minute or an hour-long opening statement, right?
No, it's we're not the show. And as soon as, the sooner we learn that our job is to get the information to the jury and let them do with it what they will, and give it to them in a way that is concise and accurate, the better off we are. But, we just can't do that. And so the opening, forces you to really stay focused on what's important and making sure the jury gets what they need and when they need it. Because you go through in the opening, when you give them a statistic and you give them the rules, you give them information, and then it rises to more advocacy towards the end, but you don't come out of the box lecturing the jury. And so you're able to provide the information in a systematic way, which really simplifies things for lawyers.
Yeah, definitely. I mean, what you're talking about with how many facts we have to deal with in a lot of these cases, especially the more complex ones with, well, I don't know, even your quote unquote simple car crash case is very, very complex with facts a lot of the times. And I mean, I just find I want to tell the jury everything. Like I want them to hear it from me because I'm the only one who's going to be able to do it right. And
Yes,
I
absolutely.
definitely make that mistake.
Yeah. Yeah. We don't trust that anybody else is going to say it right or do it right. I have two kids, and my oldest is very matter of fact, and he's a boy, and my youngest is my sweet little girl. And I talk to him about my cases all the time. And I'm describing, I remember we were at lunch years ago and I'm describing this case, and then my son kind of checks out, and my daughter's like, "You're just being rude." And he goes, "No." And he tells me the story back in 30 seconds. I was languishing to tell it, 5 minutes of all, what I'm working on, what I'm doing. And he tells it back to me in less than 30 seconds. And I'm like, yeah, he didn't need all the background. It lost interest. Yeah, people are going to lose interest in what we have to say. And I don't care how dynamic we are. We just need to give them what they need at that time. And then we got so much more. There's so many other things that we're trained to do that we learn to be good at. And then we need to wait and tell that story.
Is there a particular tone that we're trying to set during opening, or is it pure delivery of the facts? What do we expect to get out of the college as far as purpose?
Yeah, absolutely. And that really is, that's, what we're doing is we're going through at first getting the attention of the jury. Why is this case important? Why is it something that they need to look at? And then we're giving them just the facts about what the story of the case is, without making it a situation where we're advocating. Because if we advocate too early, the jury says, "Nope, that guy has an agenda. That guy has a bias. I knew that." You know what? All that stuff they did during jury selection, where they said, "Hey, give us an opportunity to give you the facts and bring you this, and you as a jury will take care of it." Nope. You jump up here and then you start telling me, you're that slick trial lawyer that's telling me. So yeah, so we have to come off of that. So the opening statement is set up to where we go from starting with getting their attention to giving them the facts, to then as we go through the opening, we're advocating more. Without ever really getting into never getting into a closing mode, but still giving the information and giving it in a way that is, they know by the end whose side we're on, why we're on their side, and why it's important. But that's not the first thing that jumps out to them.
Okay. Another is an undergraduate openings, and then there's a graduate you mentioned. What's the difference? Are there any differences? Do we need both in the beginning? Do we need both overall?
Absolutely. And this is something that we've really agonized over through the past few years. So like we were talking about earlier, the edge evolves, the edge changes, and the opening statement has changed. But you can't get to where you need to be in a graduate level opening until you do the undergraduate. Even though there's some refinements, there's some differences, and they can be quite significant. It's hard to teach that until you learn the underlying openings. And that really is one of the hardest things we have, is really learning, sitting through those courses, bringing your opening, writing it, giving it, and having your instructor and having, your co-students go, "Nope, too long. Doesn't make sense. Got to make it shorter. That's not what we're doing. We need something different." And so doing that can be a daunting task. If you tried to jump straight into the graduate level, it would just be too hard. So yeah, the undergraduate level is really important, of learning the structure, why we do things. And then the graduate level is very helpful to modify things. It simplifies it to some extent, but you need to learn to walk before you can run.
would you encourage folks to do the undergraduate one and then the graduate one kind of early on, maybe back to back, or how is that?
Yeah, and I can't remember. I'm pretty sure that you qualify for graduate opening pretty soon after your undergraduate opening. So yes, I would. I would very much encourage taking the undergraduate and then taking the graduate. And I would recommend to everybody, take opening. You take rules, then take opening. Yeah, and a lot of people don't. They're like, I need to know. Focus groups needs to be up there too. So that's one that's up there. But yeah, use your opening to teach the roadmap. And so you need to get to that. And so, yeah, I would take it early. And then as soon as I could take the graduate level one, I would take it as well. Absolutely.
So once you've taken these courses, and as you have different types of cases coming in, can you modify the opening to fit those cases? I know I get a lot of questions from people who practice employment law. We also practice employment law. There are little nuances that are different. How does the openings college, both undergraduate and graduate, I suppose, to the extent you can speak about it, form a foundation for a bunch of cases?
Yeah. So the framework applies, the framework applies in a bunch of different areas. And so it's so hard, right in your first opening, right in your second opening, right in your third opening, it gets easier and easier. But yeah, but it applies because once you realize what the framework is, why you're doing it, what it is, well, then all of a sudden those things flow into one another. And then you know what you're looking for. Oh, when I take this deposition, oh, this is, this is the quote I'm going to want for this section of my opening. So let me go get that from their expert. Let me go, I want them to agree to my statistics. So let me get that. Or I need this, or I'm doing this type of case. Well, the framework applies to any type of case. I know with employment cases, that there's a huge hang up sometime on the rules. Well, it's not a safety rule. It's not really a safety rule. Well, I don't know about you, but what do we need for safety in our lives more than a steady paycheck so we can pay our bills and our kids can go to school and all those things. So they do apply. You just have to figure out how to modify it and realize that, yeah, this really is a safety rule. It's not for my physical safety. I'm not going to be physically injured, but I am going to lose my job. I am going to lose my car. I'm going to have to go do something different. I lose that safety and that security. But so with your opening, those sections apply because you still have to tell them the story of what happened. You still have to have your rules in there. You still need to talk about, why you're suing your defendant. And those are all things that that framework applies to a lot of different cases.
Okay. Let's see. So what should we expect to have in our hands at the end of the undergraduate opening college?
So Jenna, that's a great question because you know what you will have at the end depends on what you show up with in the beginning. And this is the one college where you need to do two things to get the most out of it. One, do the opening, do the homework, and do an opening. And it is the hardest thing people do because it doesn't make sense. It's hard to do. You're just like, oh, I'll wait till I get there to do it. And then there's too much. It's one of those deals where this class could easily be 3 days. And this is why we have an undergraduate and a graduate course. It easily could be 3 days and still not get it all done. So one, you need to, get look at the different cases, the blogs that are provided, the examples that are provided, and then you need to try to write it. And it's going to be hard and it's going to take a really long time. And it's going to be horrible. But when you get to the course, and Jenna, and you've taken these courses, and and so for the people that are edge folks that have taken these courses, you know what happens when you get to these college. You work on things. These are not lectures. Well, and I take that back. They can be. If you just want to show up, or if you just want to log on and just watch and not participate, well, you're not going to get out of it what you can. And so that's it. So you have an opportunity to take this opening that's in bad shape, but you're going to be one of the only or 2 or 3 people that actually have it. And so we're going to work on your case because we're going to have it. So one, do it. Write an opening, no matter how bad it is, no matter the fact that you don't understand it and you're going to get it wrong. Go ahead and do that. And then when you get there, and whether it's in person or on Zoom, when the instructor says, who wants to work on this section? I do, and so, and that's the first thing I tell everybody in any of the classes I teach. Be the one that says, squeaky wheel gets the grease. Be the one that says they want to do it. And if, it's been years since I've had anybody fight going, oh, so-and-so is getting too much attention. There are a lot of people that are just fine to watch it and not, and then afterwards they're like, oh, that didn't make sense. Or, oh, I wish I would have. Well, you got to speak up because you got an instructor and then you got, several other really good lawyers that are going to make your case better. So that's it with your opening. You need to bring one, write it, and don't say, well, I don't know how to write it. That's why I'm going to that's why I'm going to the course. Well, you don't know the way we do cross-examination for the edge, and you don't know the way we do rules for the edge, but you still take a stab at it. And so that's what you do. And the more prepared you are, the better off you're going to do, and the better experience you're going to have.
Will we come out of it with a full opening ready to go, or parts of it, or what?
If you will come out of it with, if you come in with it pretty well written, you'll come out of it with about 3/4 of it written. There's not enough time to get all the sections written. And so, but you'll come out with most of it. And again, it's if you're going to put the work in. If you're going to go back to at that night after class, if it's on Zoom, then you're going to go back and you're going to write it and you're going to put it together. Then yes. But if it's going to be like, no, okay, now I got the notes and I'll do it later. Then no, you won't come out with it because it's really difficult, especially when you get to the very end. The damages, it's rare that we're able to get all that. You get the lecture, you get you get what it's supposed to be. But if you showed up with all 5 parts of yours written, your instructor will help you get through the rest of it. Absolutely.
For those of us who've taken undergraduate openings in the past few years or so, maybe 3, 4, 5 years, do you encourage people to do it again or look back at our notes?
Go take graduate.
Okay. Go
take graduate. Because, you qualify, you've done it, go take graduate. They're going to modify it. They're going to show you different stuff. And you're going to be able to apply the stuff you did 3, 4, 5, 6 years ago. You'll go, oh my God, this is amazing because it's so much simpler. And the reason it's simpler is because you already have that foundation. You already have that muscle memory of working through the opening. And so then when it's simpler, when it goes from a 30-minute opening to a 15-minute opening, you're like, wow, this is awesome. But if you try to teach the graduate level opening to folks that have never done it before, that have never seen an edge undergraduate opening, oh, the pushback, the blowback, I can't do it that way. There's no way. I need to. And so, but once you've done the first undergraduate opening, and you've worked it, and then you go, okay, this is why this system works, then you're able to take the graduate one and go, okay, I trust this. This works for me.
Toby, will you share with us a little bit about what brought you to the edge, formerly Reptile or whatever, and how this course in particular, learning it, developing it, and teaching it has enhanced your practice?
Yeah, absolutely. So I was one of these guys that never, my goal was not, I didn't grow up wanting to be a lawyer. It wasn't, I want to be a trial lawyer. This is what I want to do. In fact, I was in law school when I figured out that I wanted to actually be a lawyer. So I got, and you can probably tell with my head right here, when I was 18, at my high school graduation party, I dove into the shallow end of a swimming pool and I broke my neck. So I floated to the top of the pool, face down, couldn't move anything. And luckily they got me out, got me to a rehab hospital, and I didn't have a whole lot of complications other than the fact that I'm a quadriplegic. I can't move anything from my shoulders to my legs. And this was back in 1990. In 1990, there's no internet. There's no DVRs. When you go home, there's not a whole lot of things to do. So I wanted to go to college. That was my plan before I got hurt. I was going to go have fun at college. I didn't have any career goal in mind other than to hang out with my friends and have a good time. So I started going to college, and after 4.5 years, they said, "Okay, here's your degree, go forth." And I thought, well, hold on, I can't move my arms or my legs with an undergraduate degree. I can't really go get a job. So I started taking an MBA and my law degree, and my goal was to stay in school and get a PhD and then go teach college, because I thought that would be a great way. That's the easy job, not an easy job, but a job that somebody that physically can't move. So I started going to law school and getting an MBA, and then firms wanted me to clerk for them because they wanted to have a little bit of the experience of somebody with a disability. And this was back in the mid 90s where there was all type of mergers and acquisitions. And I thought I was getting an MBA. I wanted to do that. And it was boring, but I worked for some defense firms, and the PI cases I worked on were intriguing. It was learning why the stairs at a stadium failed, or why did this chemical plant explode, or why. So you got to learn, and you watch these fabulous trial lawyers go into depositions and just totally annihilate each other, and then go off the record and act like they're best friends, and then go back on the record. And then I realized that I had a certain expertise in having a disability. And so they would ask me questions when they would have folks with spinal cord injuries. Well, do you really need a band? Do you need this? Do you need that? Why do you need it? And then I realized that people wanted to hire me for it. And I had a really good trial ad professor that said, "Toby, you need to go do defense work for 5 years. They'll teach you how to be a lawyer. They'll train you." So that's what I did. I went and I did defense work, and instead of 5 years, I did it for 7 years because I had a family, but eventually I realized that I wanted to help people, and I worked for good companies. I never, back then, the folks that I worked for, we paid a lot of money to a lot of people. We didn't, we weren't the black hat that just totally, how can we screw somebody over? So, it wasn't like I couldn't sleep at night thinking that I was trying to get over on anybody. But I wanted to practice plaintiff's work. So that's what I did. I started doing plaintiff's work, and I just wasn't fulfilled. I had a couple partners. We had great cases, but it just felt like something was missing. And I don't know about other folks, but I had that major imposter syndrome. Even though I had tried enough cases to be board certified, I worked on big cases on the defense side. I was working on big cases on the plaintiff side. I really kind of felt like when I tried cases, I was kind of stumbling along. And I forget who it was that said, "Hey, read this reptile book." And so I did, and it was interesting. And then it was, "Hey, you want to, here's this seminar." And I remember it probably took 5 or 6 seminars, because that's all there was, seminars back then. And so it was, here we're going to Chicago. Now we're going to Atlanta. Now we're going to, we're flying all over the country to go to these things. And I remember, they would give out a syllabus or itinerary about all the things we're going to go through. And this is back when, when Papa Don and David Ball were doing it together. Don would do one day and Ball would do it another day. And there's this whole agenda of all these things that you wanted to do. And they got through maybe a third of it. And it was like, well, no, I need more. I need more. I want all these things. And there was just no way. And as I got through more seminars and spent more time with more people, and I remember, I think Papa Don was smoking a cigar one day in Minnesota or someplace. out, and he was talking with some of the other folks that he had traveled around the country, and I really hadn't met him at this point, and he was kind of agonizing over, am I giving the people what they need? Because you just can't get the entire edge, even if it's we're going to talk about opening here, we're going to talk about depositions here, or focus groups here. Just couldn't give enough of it. So when the colleges rolled out and we got to go spend 2 days, and these all were in Atlanta then, and we all went into a room and we worked on them, and we worked till midnight every day, and then got back up, and so it helped me. I remember sitting with a very good lawyer, and we were talking about doing the EDGE system, and we looked at each other, and he said, you know what? We were committing malpractice before. We were missing out, and it's so simple, but the stuff that we were doing, and we, I forget, I never can remember the name of the syndrome or what they call it, but it's when you're talking about something and you don't know what you're talking about, but you really believe you know what you're talking about. And so that's it. We all talk like we knew what we were talking about, but we had no idea. And we'd get verdicts back and we'd go, wow, that's disappointing. Or we get verdicts back and go, wow, I'm surprised. Or, you would go talk to the jury. The jury would say, well, why didn't you ask this? Or why didn't you emphasize that? Because that wasn't important. And we would go back to the office and go, they totally missed it. They didn't know what was important because they wanted us to talk about. And then we learned focus groups, and we learned all these other techniques to just not believe our own bullshit. And it was eye-opening going, okay, it wasn't that they weren't getting it. We weren't getting it. What we thought was important and what we thought needed to be said is not. And so that's kind of that, once I started realizing that, I was hooked on the system, and I needed to know more and do more and find out more, because the better I do, the better I can help my clients. And ultimately that's what we're here to do. It's if we're not making a difference, if we're not making the lives of our clients better, and if we're not making our community better, if those are things we're not doing, even if we're making a ton of money, it's empty. You go back to your big house, or you jump on your jet and go wherever you want to, and then you're miserable. But, we all have those stories of somebody that just said, we've represented or been with for years, helping them. And then even if you lose their case, you're still family to them because you were fighting the good fight. And this system helps us fight the good fight better. I'm not sure if I answered your question. I just talked forever and ever, but.
No, that was great. I'm just thinking of a million different things to ask about it all. But I think, it's interesting what you talked about with going into defense first. And I just had this conversation with a colleague of mine who was defense for a long time, insurance defense.
Yeah.
And I said, if I had to do it over again, I would do insurance defense first. Cause I want to get, cause it's, what do they say? It's the smart player plays our opponent, not the game.
Yeah.
And I think I would have had a better idea of what that was. But when I went to law school, I didn't know I'd never met a lawyer in my life except for my law school professors. Sure. I didn't know what tort was. I didn't understand that tort law was this kind of trial lawyer thing. I was terrible in trial advocacy. They gave me like this most improved award at the end because I was so bad at it. And then I come out and the first thing I start doing is workers' comp, which led into personal injury. And I just have, fumbled along for a long time before finding EDGE. But it is interesting that you were able to get that experience and now use it for good.
Yeah. And it's so hard now because we don't get the trials that we need to get. And that's how, back then, that's how you learned. That was what most people did. They went and did defense work. Now with tort reform, you gotta be careful what you ask for, because these lawyers that were partners in these big defense firms, 20 years later are taking depositions on these small auto cases because they devastated their own firms. So it's hard for young lawyers to go join a firm and get experience. The partner that I ended up working for, he left a bigger firm and went on his own and asked me to be his first associate that came out. I took my first deposition the day after I was sworn in. I was board certified in 5 years, which is the shortest amount of time you can take to get board certified. And I never second chaired a trial. It was, and we had big cases. We didn't have a lot of small cases, but I got to know the adjusters. I got to know the insurance companies, and they wanted me to work on their cases. Because I was hungry for it. But don't get me wrong, it wasn't fun from the standpoint of, you worked 6 days a week. You got there early, you left late, you build time. I tell people it stole my soul, 0.2 at a time. But I learned how to try cases, and I was lucky. I worked for a very, very good lawyer that taught me how to try cases. And so it's so hard now. So when you want to go out and be a trial lawyer, it's hard to find place to do that. But you know what? There are a ton of firms that don't like trying cases, and that take them and they, and it just languishes in their files because they can't get it settled. They took it thinking they were going to get a settlement, or it was a referral case, and they don't want to try it. So it keeps getting continued and continued. And I remember a lawyer telling me once, that's what she did. She went in and said, give me a case to try. I don't care what it is. I don't care how, what a dog it is. I will try that case. And that's what she did. And so that's almost what you have to do now. If you can't get in a defense firm, and there's not as many defense firms trying cases, but the lawyer that shows up and says, I want to try the case. Because here's the deal. If it's a really bad case, whether on the defense side or the plaintiff side, it's not, if you lose it, it was a bad case. If you win it, you're the hero. So show up and say, I want to try the case, because, especially when the thing that we get to do with the Edge is all the practice.
Mm-hmm.
The practice and focus groups that give you the confidence, the practice in doing the things that you need to do, the systems to do it, the jury selection, the voir dire course, the opening that give you that structure. So it's not like you're just stabbing around in the dark. And so, I encourage everybody, but even now, I don't know if you can join a defense firm and then, if they're not getting trials, if they're not trying cases, then you're not going to get the same experience. So.
Yeah, definitely. I mean, I feel we talked a little bit about this with Carrie Jones last week, where we can do a lot of talking. We can do a lot of these courses. We can do a lot of strategizing and hoping and thinking about it. But if you're not getting in there once in a while to do it, how do you really know if it's going to work? How do you know you're doing it right? How do you know you really understand it unless you get in there and you put it to the test? And we do get fewer and fewer opportunities to do it, but I just encourage everybody to do what you can. Get a really good client that trusts you and wants to go the distance and is fine with the outcome. Find cases like that.
Absolutely. Or call up somebody and say, you got any cases you need tried? I'll go try it. I'll try it with you, or I'll try it for you. Mm-hmm. I've never tried a case before, but if you have a case that I'll go do it, and they'll go, okay, here's a $250 property damage case that's been in my file for 5 years. Go do it. And then go down and watch. And ask, I don't at this point with what I do and how I do it, I never take a deposition by myself. I always have a second lawyer. We prepare together. We know exactly what we want to get. And then I ask the questions and they tell me, we take a break. Did I get it? I don't think so. I think you got a maybe. I think you got a qualifier. I think you need to clean that up. Okay. And so, taking second chair to something like that. But the other thing is, and we're good about down here in Texas because we have a lot of Edge lawyers, especially here in Houston. When someone's picking a jury, go offer. I never pick, you can't pick a jury by yourself. I don't care how small the case is. You need people that are trained. The folks in our office, we train through focus groups and through, visiting with one another, how we're going to do things. And so, so that's one of the things that we do here, but go sit in there and help somebody pick a jury. I've never had anybody where they said, I'm picking a jury. I said, you want to come down and watch and take notes? Yes, please. Yeah. And they may want your, at the end of it, it's fast and furious. They may want your notes, or they may say, I'm good, but you're sitting there going, Okay, that did not work. I can't tell you how many bad versions of edge jury selections I've seen. And I'm talking about me too, because I took the jury selection course and I had a products case like 3 weeks later. And I went and tried to do that without doing any work in focus groups. And it was horrible. It fell flat. I wasn't good at it. I couldn't. Now I can talk to juries because I practice it, but I practice it in focus groups because I'm not getting 5 trials a year or 6 trials a year. I'm lucky if I get 1 or 2 trials a year. But go help other people or tell them, I'll go try your case. If you're afraid to go to trial, then you're not going to go to trial. If you don't have the cases to generate a trial, then go try somebody else's case because the odds are they'll love to have you come down and have a second chair for free. Or if they have some case that they just need to get rid of, because if they don't and they don't want to go do it, and if it turns out badly, then who cares? You did your best, and that was better than that case just sitting in somebody's file folder.
Mm-hmm. Absolutely. It also gives you practice with responding to judges, communicating with judges. I think that's a very difficult skill, especially when we have a lot of judges who just choose not to follow the law. They don't care about black letter law. They are going to make you do what they want you to do no matter what. And in the moment can be very difficult to woodpecker around that. But if you do it more than once, and I mean, I'm just speaking from the different things that I've been learning lately, is that if you do multiple trials all the time, you've got really bad judges just who either don't know the law or do know it and don't care about it. You're better able to think on your feet if you've had the practice doing it.
Absolutely. And going down and watching it and seeing it and being part of it. I'll go do that hearing for you. Not my case. The judge is mad at me or for whatever reason, not your issue. But you've been down there, you've seen it, you've done it. And, we're lucky. And I've practiced since 1998. So I've practiced for a bunch of years now. Houston is watching, I was watching a podcast or something with Lisa Blue, and Lisa Blue, talked about how, Houston had these fabulous trial lawyers. They were known, and they were known for what they do and how we do it. And so I was on the tail end of that, watching some of those guys, and Rusty Hardin is still around. And so, Rusty Hardin would get lambasted by the judge. It was Rusty and the jury against the judge. It was knowing that if you have an unfair judge, if you have, if you're being treated, wrongly, well, the jury doesn't side with the judge, but you need to learn to be able to lean into that, have that experience to go, you know what, I was right with what I did. I did it for the right reasons. I did it the right way. But you have to learn those things. And you have to learn when the judge is already with you, shut up. Mm-hmm. Don't try, judges like, Mr. Cole, I already read the briefs and he's already given the other side an earful. And then, he looks at you and says, do you need to add anything? Don't pile on. Mm-hmm. After he's done your job for you, no, sir, I think you have a fair grasp of what's going on, Mm-hmm. And so, but you got to get in the room. Mm-hmm. What I talk about, with a lot of people, I do a lot of volunteer work with other folks that get spinal cord injuries. And we talk a lot about being at the table, having an opportunity to have a seat at the table. And you can't have that if you're in your living room. If you don't get out, if you don't be part of the world, then you don't have a seat at the table. Same thing. If you want to try cases, then you need to have a seat at the table, which means you got to go to the courthouse. You got to do those things. And so you got to practice them, and you got to work hard at it. And it's uncomfortable and it's horrible, and you feel like you're going to die and you don't want to do it, mm-hmm. but you just have to do it.
Mm-hmm. It gets easier, I guess. I'm not saying from personal experience, because it's still really, really hard for me. It's very awkward and very scary, but
well, I think about Bette Midler. Mm. Darn it. Barbara Streisand. Barbara Streisand, beautiful voice, so successful, right? She has horrible stage fright. Oh. Horrible stage fright. After all the years of everything she did, she would say she would throw up before every performance. She hated every performance till she started doing it. So I don't know if it gets easier. I don't know if it gets better, but we get better at it. And we get, but I don't know anybody that doesn't still have anxiety. I mean, what we're doing is unnatural. And
it's completely ridiculous when you think about it. It's so unnatural.
It's so unnatural, and it's not for our benefit. Mm-hmm. You know, if we win or lose, we're going to go home. Our children are still going to love us. We're still going to have colleagues. We're still going to have friends. All those things. Our life is not going to change. Win or lose, while we're sitting at that table and we look over and we see the other side celebrating because they beat us. You know, we ask ourselves, would I rather be over there with them, or would I rather be right here? You know, and most of the time, every time I've ever had that experience, I'd rather be where I was with a loss than over there with a win. So we have all that. So that's with us. But with our client, their case is over with. So, you know, we have that burden that we take in with us. But the reason our client's with us is because they trust us to fight for them. And they trust us to change whatever hurt them, whatever went wrong. And be their voice. And so, you know, it's our responsibility to get better at what we do. And that's by trying cases, that's by taking more education, by doing more of it, and being better at what we do so that we can make that change that needs to be made.
Toby, since you had a lot of experience trying cases before getting involved with the Edge, and you also have a lot of experience after, can you share with us how the openings template course and what you learn through that how have you seen it change your effectiveness in the courtroom?
It's night and day. It's night and day. It's like, it's like trying to find like going someplace and you don't know exactly where you're going, but you're like, I know I've been there once before and it's in the back of the neighborhood. You know what? Let me turn down this street. Nah, that's not the right street. So then I turn down another street. That's not the right street. And then hopefully I find it, either I find where I'm going and I'm like, oh, that took longer and was more stressful than it needed to be. Or I'm just like, well, I didn't quite get there, but hell, I'm done. I'm going home. I'm done. Or I have my directions and I know exactly where I'm going. I go to this stop sign, I take a right. I go back past this house, I take a left, and I get where I'm going and the stress is less. I'm communicating what I need to communicate. And so it's just a situation where I'm not just taking a stab in the dark. And I was one of those guys too at the beginning going, you don't need to write it down. You know your case, you know what it's about. Just get up there and go for it. And, and then, I did the thing where I have it written down where I'm going to go. And then I deviate from it and I slip back into old openings, loss, stream of consciousness opening. Or I go watch somebody do an opening and I see them start with the process of it. And then partway into it is nope, old school. And then they're just, and there's no rhyme or reason. There's no roadmap. And it's just harder. It's stressful. And it's not as effective. And you may win your case. You may do great, but it just, it just makes it easier on everybody, on you, on the jury, on everybody.
What about teaching openings makes your practice better? Do you encourage people to try to get into teaching in addition to attending?
Absolutely. Absolutely. Get on faculty. You don't know what you don't know until you start teaching it. And you don't know how well you need to know it until you start teaching it. And so it solidifies exactly what the course is about, why it's about, why you're doing it. And then I'll go home after. I teach different classes now, and every class, even if I've taught it 15 times, I learned something new when I'm done with it. So, and here's the secret that someone told me early on. And I'll tell this to everybody when they, when they become faculty, or if their thought is, well, great, Toby, you're faculty, but you've been doing it for a long time. And so, maybe after I do 8 or 9 or 10 trials, then I'll start teaching it. Don't wait for that. And here's the other thing. You don't need to be the expert in it. There are really, really, really good lawyers that you're going to be with. And the secret of it is when they ask you a question that you don't know the answer to, just ask the whole course. How would y'all handle that? Let them talk. And you need to do that anyway, because they need to learn from each other. Find out how they would handle things. And so that just takes the pressure off, because none of us are Papa Don. And so we're not expected to teach the way he teaches and be who he is. But we all learn from one another, and we're all better for it.
In all the colleges that we attend, the lawyers are at a level that they want to be there and they want to be participating. And just for those of you watching who have considered going or are thinking about it, you are, just like Toby said, you're really dialoguing and discoursing with other people of like mind. And you're not, other people might know more than you, may have done more trials, and you'll learn from them. And also maybe you have a different experience that you'll be able to share, and other people will learn from you. So as much as, there's a faculty person who's going to teach you massive amounts of really awesome new stuff, the double benefit is you're also going to be there with other people who want to be there and who are going to also enrich your experience. That's my dog. Sorry.
I love it.
So I just kind of in closing, Toby, how does the quality of the students make these colleges that much more special?
Yeah, you don't get people just showing up that don't have a strong desire to be better at what they're doing. There are sometimes there are lawyers in the room and you're like, oh, this guy has multiple 8-figure verdicts, and this guy has done this. And, oh yeah, this guy came over in his private jet. Oh, or all those things. And
Bill from Florida, he's really good.
Yeah. And so there's everybody, and there's no egos. There's no, nobody looks around the room and go, that was a stupid question. Why are you doing that? Oh, I would. It's not that way. And it's not, the thing that's really hard for me is I remember, there are, ATLA conventions or these other things where you go to these, $500 a night, $750 a night hotels in Hawaii or Las Vegas or these places. And there's no content to what you're getting. This is just all content with people that are working really hard on what they're doing. And I was, there's mixed blessing to COVID, with all the devastation that it's wrought on a lot of people and their families. We've learned to do things differently. Before COVID, I took a few teleconference depositions and they were horrible. There was lag, you couldn't do things. And my attitude was, I'll never, I got to be in the room. I got to make eye contact. I got to be with them. Now, I don't think that's true. You can have complex products cases. We have people throughout the country, lawyers throughout the country, and it doesn't take you 5 years to get it tried because everybody can't get together. And the same thing with teaching. You could have that contact. I mean, I miss the days when we were all traveling together and we were in rooms together. It was nice because these same people that are like-minded, you're having lunch with them and you're visiting with them. And so some of my best friends are lawyers that I've spent time with, and they're out of Arkansas or Austin or Florida now or wherever they are, people that I've gotten close with because the folks that, like you said, Jenna, we're like-minded. We want to do the same thing for the same reasons, and that's why we're there. And so you're going to be in those rooms and you get that feel through Zoom too. So it's not like you have to get on an airplane and be gone for 3 or 4 days. You get to the office, you turn your computer on, you work on your course, and then you get to go home and sleep in your own bed, and you get access to this really great information. And then you have a group of lawyers that you spent 2 or 3 days with working, you can call them up, or they have your case. They have you're working on a auto case, but they have a products case, and you're like, shit, that's my case. Hold on, let me take notes on this opening or on this whatever. This is okay. Yeah, I got that same thing. Oh, can I call you later and maybe get a copy? All those things, and so it really is. It really is a neat group of people.
It is. It is. All right, Toby, we're just about at the end here. Thank you so much for being with us today. And thank you to all of you who joined us for this week's episode of Keenan's Cutting Edge. If you liked today's episode, please click that thumbs up to feed the YouTube algorithm. And don't forget to subscribe and sign up for alerts so you don't miss an episode. Next week, we will continue the KTI Faculty Speaker Series with Blake Johnson, who will be speaking to us about the trial college. This one is important because of all the colleges I've attended and the ones I teach, trial is kind of the most confusing for students. So make sure that you join us next week if you have questions about what exactly this course entails. Blake practices personal injury law in Utah and is the dean of the trial college. He has taught me so many of my KTI colleges and has a wonderful personality and a dynamic way of communicating information. And so I look forward to hearing about the trial course along with all of you from Blake next week. Have a wonderful weekend, and I will see you next time.